It's time for today's Legal Minute with the Law Office of Cooley, Shrair in Springfield. Today, we're joined by attorney Shawn Willis. Once again, we're talking about domestic violence as it relates to the workplace. Now, as we were talking about a couple weeks ago, there is so much to think about for someone who's a victim of domestic violence, so we should make it easy for them in the workplace. How does it relate? What's the relationship like between your employee and your domestic violence charge?
Well, as I explained last time, the new Massachusetts law actually now provides that employers with 50 or more employees now have to allow employees who are victims of domestic violence or have family members that are victims of domestic violence to have up to 15 days of paid or unpaid leave within a 12-month period. Now, with the family members, the statute actually defines the family members as children, spouses, domestic partners, siblings, grandparents, grandchildren.
And I'm sure if you needed to, you could request an exception, and maybe, just maybe, it would be granted. Now, we were talking earlier, you don't have to be paid for that time off.
No, the statute only provides that you have unpaid time leave. However, employers have the discretion of requiring their employees, when they take the time off, to first exhaust any accrued time that they have, like vacation, sick, personal time.
So they could kind of force your hand and say you need to take your vacation days and your sick days. Now, another important thing is the advance time, because often in domestic violence situations, you don't know that it's about to happen to you.
Emergencies.
Emergencies, and those
Absolutely.
pop up so often. How do you request that time? Do you have to do it in advance?
Well, in a way similar to the FMLA, employees are required to give advance notice unless they're in a situation where there's an immediate threat of danger. With the advance notice, basically the employer can only require the same type of notice or amount of advance notice that they require for all their other time off policies. But with the immediate threat circumstance where it's unscheduled, as long as the employee provides documentation, within 30 days, the employer cannot take any type of adverse employment action against the employee.
So you don't have to take these 15 days all at once, too. This can be something that you take in piecemeal for an appointment or for a therapy session.
That's correct. Actually, you can take 15 days off if necessary. You can take half a day. You can take a couple hours. The important thing is your job's protected and your employer cannot take any type of adverse employment action against you.
And as always, if people have questions about anything that we talk about, no matter what the segment is here, all they have to do is contact the Law Office of Cooley, Shrair.
Sure thing.
Thank you so much for stopping by. That's your Legal Minute. And for more information, you can call 413-781-0750 or visit CooleyShrair.com.